Hello, everyone, and welcome to the Dallas Democratic Forum's 7th program for 2021, a Supreme Court review, the 2020 to 2021 term. This is always one of our most popular programs, and we have a distinguished panel with us today, whom we will introduce in a few minutes. I'm Leslie Oshman, president of the Forum. For those of you who are not familiar with the Forum, we began last year at our normal venue, the beautiful Bilo Mansion, which is now known as the Arts District Mansion. Our program topic was the crisis in the Middle East. Then COVID hit and we transitioned to using Zoom. For the next 3 programs, we featured Professor Rick Hasen, a leading expert on election law from UC Irvine School of Law. And after that, we heard from our Dallas County DA discussing ideas for criminal justice reform and, of course, our annual Supreme Court review. In mid-September of 2020, we hosted a program featuring 3 former U.S. attorneys on the crisis in the Justice Department. And at the end of September, we hosted Harvard professor Daniel Ziblatt speaking about his book, How Democracies Die. In October, we heard from Krista Castaneda, candidate for the Texas Railroad Commission. And in November, after the national election, we had a wonderful panel moderated by Todd Gilman of the DC Bureau of the Dallas Morning News and a panel of political experts. At the beginning of this year, 2021, we offered a unique program, a film about city government by a prominent American documentary maker. In early February, we had our formal kickoff with Jeff Engel, director of the Center for Presidential History at SMU, who spoke about President Biden's fast start, a historical comparison. In mid-February, we presented U.S. Representative from Houston, Sylvia Garcia, who spoke to us on reflections on impeachment and the Senate trials. And at the end of March, we had the one and only Robert Reich, who spoke about his new book, The System, Who Rigged It, and How We Fix It. And in May, we again featured Jeff Engel on the president's first 100 days, Is Biden the Next FDR? Last month, we had a review of the Texas 87th legislative session. We have been bringing these Zoom calls free for our members for the past 15 months and hope you have enjoyed them. Today is our last Zoom call, and I can't say we're crying about it. We're pretty happy that we're going to be going back to our normal venue. In September, we are returning to that Arts District Mansion, again, formerly known as the Bilo Mansion. And I would like right now at this time to say a special thank you to our VP of Programs, David Griggs. He has managed all but 3 of these Zoom calls these past months. This is not his or my professional background, and he stepped up to master the technology with all its intricacies. Believe me, it's not as simple as it seems. I hope you will thank him when you see him in September or send him a note. For those of you who have been our members, we will be sending you an email in August to renew your membership. For those who are guests today, we will invite you to become a member by the time we return to the Arts District Mansion. Your membership will be valid for the rest of 2021 and all of 2022. If you're not familiar with Zoom calls, please look at the bottom of your screen for the chat feature. You will be able to ask questions that our moderator will select during the Q&A period today. We will try to answer as many questions as possible. And now, without further ado, I would like to introduce our VP of Programs, David Griggs, and he will now be our former Zoom call meister. And he will introduce our moderator today, Jason Steed, who is also one of our former directors.
Thank you, Leslie. Appreciate that. Yes, it's a great honor to have this program. It's an annual program that our board member, Jason Steed, coordinates and plans for us. Jason is an appellate attorney at Kilpatrick, Townsend, and Stockton in Dallas with extensive experience in both state and federal appellate courts across the country, as well as the Supreme Court. He had received his JD from the University of Texas School of Law. He's a former English professor with a PhD, and he regularly publishes articles and gives presentations on the U.S. Supreme Court and other legal topics. He asked me to make this brief, so I left out about 3/4 of his bio. But anyway, we're very happy to have Jason here to moderate the program. So Jason, I'll turn it over to you.
All right. So that was still not brief enough there, David, but I will, I won't say so much. Those of you who've registered for the program, I assume that you were able to see introductory information about our panel members. I will say I'm honored to have these three panel members today. Dan Geiser has argued 11 times before the Supreme Court. Deepak Gupta has argued 5 times before the US Supreme Court. Jamie Santos, like me, has been involved in a lot of cases before the Supreme Court, although neither of us has had the opportunity to argue yet, I don't think, unless, Jamie, did you slip one in there that I didn't see? I don't.
Still trying.
Yeah. So, but all three of them are very experienced appellate practitioners, excellent lawyers. I'm very happy to have them here. We're going to talk about the Supreme Court's previous term. I'm just going to say a few words really quickly before we turn to the actual cases about the court. This is the first term that we've had Justice Barrett on the court. So I think there's a lot of trying to figure out where the court is going and what's happening with the new 6-justice conservative majority. The court decided 67 cases on the merits, which continues a trend downward in the total number of cases that the court is hearing. The court used to hear 150, sometimes pushing 200 cases, used to decide that many cases pretty regularly. In the early 80s, that came down to around 100. Chief Justice Rehnquist in the mid 80s brought that down under 100. The court was deciding just under 100, around 90 to 100 cases per term under Chief Justice Rehnquist. Chief Justice Roberts has brought that total down even further. And I don't mean to imply that the chief is entirely in charge of how many cases get decided, but certainly has some influence. I think that over the last few years, we've consistently, I think, I didn't go back and count, but I want to say 3 or 4 years now, where we've consistently been under 70 cases per term. I think since Chief Justice Roberts took over, I think immediately the total was brought down to 80 or 85, and then it was 75 or 80, and then it was 70 or 75. And now, like I said, I think we've had several years where it's been 68, 69. This year was 67. So that seems to be established now as a new trend with the court, is deciding just fewer and fewer cases, really comparatively speaking, not deciding a lot of cases. The court this term had 43% of its opinions were unanimous. I usually like to point out how many opinions were unanimous because the court gets a lot of attention for its divisions. But 43% is about on par with over the last decade or so. I'd say 40 to 45% of the cases are unanimous every term. That's quite a bit of unanimity, and the court, like I said, doesn't get a lot of attention for the unanimity that it has on a lot of cases. Of course, a lot of those cases are very uncontroversial, bankruptcy cases and things like that. But still, it's important to point out that they're not divided on everything. The court had just 12% of its cases that were decided 5-4. That's significantly down from, I think over the last decade or so, it's been 20 to 25% of the cases were split 5-4. Anyway, there's been 6-3 opinions. There were 15% of the opinions that were 6-3. So I think what used to be measured for the court's division was the 5-4 decisions. Now, because there's a 6-justice conservative majority, we have to look at the 6-3 decisions as well to look at the division, because it's no longer a 5-4 split among conservatives and liberals on the court. So if you add the 15% 6-3 opinions and the 12% 5-4 opinions, 5-4 opinions are going to be the cases where maybe one of the conservatives swung over with the 3 liberals, or maybe 2 of them if the liberals actually got a decision in their favor. But if you add those cases together, we get closer to the 20 to 25% of divided cases that we've seen in the past. All right, so that's kind of a quick overview of the numbers at the court this term. We'll turn now to the specific cases. We're going to hear first from Jamie. Jamie is going to tell us a little bit about the NCAA case.
Yes. We thought we would start out on a high note before getting to the really depressing stuff. So I'm going to talk about a fun set of antitrust cases involving college sports. These cases were consolidated as NCAA versus Alston. They were heard just a couple days before the Final Four tournament. And the cases involved a challenge by Division I athletes to the limitations that the NCAA imposes on the benefits that athletes can receive for participating in college sports. So under the NCAA's rules, universities can recruit athletes by promising things like scholarships to cover tuition and basic expenses like room and board or textbooks. But the NCAA prohibits what it calls pay for play. So schools can't give athletes any benefit that the NCAA defines as something that constitutes pay. And in this case, the athletes were challenging a narrow set of rules that prohibit universities from providing certain education-related benefits and payments. So for example, promising a scholarship to grad school to a college basketball player in exchange for playing basketball during undergrad. If you, from a kind of antitrust perspective, and I won't get into the technicalities of antitrust law, but generally speaking, a ban on paying athletes seems like a classic price fixing conspiracy. So if, for example, Kroger and Whole Foods and Sprouts all agreed to cap store manager pay at $30,000, or if they all agreed to set the minimum price of ribeye at $24.99, then that would surely be an antitrust violation. And that's really not all that different from what you have in the NCAA context. You have an agreement among competitors, universities, to limit the compensation that workers, who here are student athletes, receive. But the NCAA has historically defended its restrictions using the justification of amateurism. So what the NCAA has argued, and generally pretty successfully, is that what sets college sports apart from pro sports is the fact that student athletes are amateurs. In other words, that they don't get paid to do what they do. If student athletes are no longer amateurs, then the NCAA has said college sports will cease to exist as a distinct product in the marketplace. The Supreme Court this time around, though, was not particularly impressed by this amateurism rationale. And this is a really fun argument to listen to on Oyez if you want to listen to a Supreme Court argument. It was very clear from the argument that several justices, including primarily the conservative justices, asked questions like, wait, is it really a legitimate pro-competitive justification to say that consumers love watching unpaid people play sports? That was something Justice Barrett asked during the argument. So it was not a huge surprise when the court not only unanimously ruled in favor of the students, but the court effectively invited future lawsuits challenging other NCAA restrictions more broadly by essentially questioning amateurism as a legitimate justification altogether. And I don't think it's much of a coincidence that in the days that follow the court's opinion, the NCAA promulgated new rules that permit student athletes to profit from their name, image, and likeness. The prior rules forbidding this kind of thing surely would have been suspect under Alston. But I think that the more that college athletics resembles pro sports, the more tenuous this amateurism rationale becomes for any NCAA limitations. And I do think the new name, image, and likeness rules make that line a lot fuzzier. The one last thing I'll mention is that I think one thing we learned that's interesting from this case and from a case involving cheerleaders that I think Dan's going to talk about later is that Justice Kavanaugh really likes cases involving sports. He had a lot to say at both arguments, and he wrote a dissent in this case, or a concurrence in this case, specifically to point out his strong view that there are serious questions about whether NCAA rules, other rules can pass muster under the opinion. He basically was begging for more cert petitions about sports. So remember that whenever anyone tells you that the Roberts Court is not pro-worker, you can tell them that's not totally true. It's pro-worker as long as those workers are athletes. And Dan, I think you are up next with Cedar Point Nursery.
That is right, and that was a terrific wrap up of the NCAA case. We'll switch to something that I think this, at least for this group, I just spoke the other night to the Federalist Society. So they think very differently about Cedar Point Nursery versus HACID than this crowd might. But But Cedar Point was a very important case dealing with takings. But that's really the constitutional question. The background context was union organization. And the question is, if you have a union that wants to organize agricultural workers, what's the most effective way to do it? And so what California does is it had a rule that says that union organizers can access the property of the agricultural business up to 3 hours a day for up to 120 days per year. And the businesses didn't like that. And they said, this looks a lot like a taking. It's an easement. You're taking away our right to exclude people from our property. You're giving them access to an area that we otherwise would not give them access to. And if you want to do that under the Fifth Amendment's takings clause, you need to pay for it. And so the case went to the Supreme Court. And unlike some of the cases where we either had sort of strange bedfellows or we had sort of an unexpected lineup, this one lined up, I think, pretty much the way one might expect with a question like this at the court. It was a 6-3 decision. It was written by the Chief Justice, and he held that the California law constituted a physical taking. Now, the part of the dispute here, and something that from a legal perspective is very interesting, was trying to draw what sometimes is an elusive line between physical takings and regulatory takings. So physical taking is very clear if someone's actually, stepping on your property, the state is coming in and taking it away from you. It's not as clear when it's a regulation that affects either how you can use property or what other people can do with respect to your property. And so when you're dealing in this case, the court looked at it and said, this is actually a physical taking because normally the business would be closed to outsiders. That is part of that traditional right to exclude, and it's been taken away from the landowner. So you can't look at it as a regulatory taking. It didn't matter that it's only temporary because the question about how temporary something is affects maybe how much you're paid for it in terms of the compensation for the taking, but not whether in fact the taking has existed. Now, this was an important case in its own right, but it also raises interesting questions going forward in other contexts. Say you have inspectors who want to get in to, one example is a meat packing plant. Can they do that? Or are they normally not want the inspector there, especially if they're violating the rules? They probably really don't want the inspector there. Are you taking away their right to exclude those people? How does this compare to, for example, old takings cases where you have an open shopping center to the public and some people want to get on the shopping center to engage in free speech activities? Can you limit the type of uses? The shopping owner may want to exclude certain people, which is usually part of the right to property. You can invite some people into your home and not others. And some people to maybe your Zoom meetings and not others. And so if you've taken that away from the owner, how does that jive here? Now, the latter case the Supreme Court dealt with here, and they said, well, you're already opening it up to the public. So a regulation restricting what the public can do there is one thing. The former case, the Supreme Court tried to say that there will be ways to account for those problems without forcing the state to compensate everyone who is resisting normal government regulation or normal government inspections. For example, by conditioning a business license on the being willing to let the state come in and take a look at what you're actually doing and if you're complying with the law. So a very interesting case in its own right. An interesting case in terms of takings jurisprudence, which often can be a little messy. And we'll see where it goes in the future, but not a huge surprise that this court, which is normally pretty protective of property interests, would see that this fell on the side of the line of a takings. And I wish I knew who's next, but Jason, I do not have our agenda in front of me, so
I think it's me, right?
Yeah, I'll just chime in real quick to say, I think one of the really interesting things about the Cedar Point case too, is it's an interesting case as a takings case in its own right, but it's also another example of ways in which the court has sort of gone about in a circuitous way to undercut labor unions, because that's the underlying issue in this case is labor unions are much less able to organize and recruit and do the work that they want to do if they can't access the property where all of their workers are. So it was a takings property case sort of primarily, but secondarily, it was a big labor union case, and the conservative majority of the court really ruled hard against labor unions being able to do what labor unions do. So yeah, Deepak, you're next with the Ford case.
Great. Yeah. So I do think the Cedar Point case is a really consequential case, and I think the court is aware that sometimes the press coverage and the public focus on the court tends to focus on hot button social issues, and actually where the court has often a bigger impact is on cases like this, which have to do with the relationship between corporations and people. The Ford cases that I want to talk about are sort of fall into that category as well. These are the kinds of cases that for people who are in the court system every day, this kind of case can have an enormous impact, but it's not the sort of case that makes the biggest headlines about the Supreme Court. So I argued these two cases back in October. I was one of the guinea pigs when we were first trying to figure out a telephone argument before the Supreme Court. So, it's a challenging endeavor always to argue before the Supreme Court. It's even more challenging when you're just talking to them on the phone. You can't even see their faces. You can't even read the room. These two cases arose, they're two different cases that were consolidated before the court, one from Montana and one from Minnesota. And they both grew out of tragic car accidents where people were seriously injured or killed that led to products liability claims against Ford. So this is the bread and butter of our American legal system. State courts hear claims like this all the time. In the Montana case, a 23-year-old woman was driving a Ford Explorer not far from her house in Montana, and the tread separated on the tire. This is a well-known defect in Ford Explorers, and tragically, the Ford Explorer flipped over into a ditch and ended up overturned, and she died at the scene, leaving her family, including some small children. In the Minnesota case, a man was in his friend's Ford Crown Victoria. They were on their way to a favorite ice fishing spot when the car crashed into a snowplow on a country road. This car also wound up in a ditch. And the problem was that the airbag had not deployed as it was supposed to, and the man ended up with permanent brain injuries. So in both cases, you have alleged defects with these Ford vehicles, and everything about these cases seems to have to do with the place where they happened. They're car accidents. The people involved were all in either Minnesota or Montana. And the claims were brought against Ford where I think everyone here would expect you would sue Ford, which was in the state courts in Montana and Minnesota. So what is the legal issue? The legal issue is about whether or not it was appropriate to bring these cases in those two state courts. And what Ford argued, and this was not a crazy argument under the existing law, was that you sued us in the wrong place because we didn't do anything there. We did not make the car in Minnesota or Montana. We did not design it there, and we didn't sell it to the first person who bought it there. These cars ended up in Minnesota and Montana through a series of used car sales. So even though we sell those exact cars in that state and advertise them there, we want people to drive our cars in those states, we didn't do anything there, and so you can't sue us. And the legal doctrine for this is what lawyers call personal jurisdiction. It arises out of the due process clause of the Constitution. And in a string of cases, the Supreme Court had always sided with corporations and held continuously limited the ability of people to bring their claims in state courts in the name of protecting corporations' due process rights. In fact, you'd have to go back to the mid-1980s to find a case in which a corporation lost one of these cases and the court sided with consumers. So when the court granted these cases, I think most observers thought you have this new conservative majority, the court doesn't tend to rule against the little guy in these cases, they're going to rule in Ford's favor. But in fact, a lot of court observers were surprised to see that the court unanimously ruled in favor of the consumers in these two cases. There was some disagreement among the justices about the rationale, but everyone agreed that Ford should lose. And almost all of the justices agreed with Justice Kagan's rule, which she wrote in the majority opinion, that when a company like Ford serves a market for a product in that state, and the product causes injury in the state to one of the state's residents, it's perfectly constitutional for the state court to entertain the resulting lawsuit. So this is a win for a little guy, and I think it shows that even in this court, this pro-business court, there are going to be surprising wins. And so, you know, I'm of course personally pretty thrilled because it's a win for us. But I think it also shows that we shouldn't be too quick to judge this court based on political caricatures in the media.
Yeah, I think, thanks, Deepak. I think that's right. I was one of the people who was very surprised by the court's ruling because of the trend going against finding jurisdiction over a company. And what I was actually most surprised about is Justice Gorsuch wrote a concurring opinion where he sounded very open to, hey, we want to consider basically making corporations subject to jurisdiction all over the place, everywhere, just as easily as we could any other regular individual, which I was sort of shocked by his openness to that. So it's a point well taken that we can't be too quick to judge based on sort of assumed biases from biases we might have about the biases that the conservative justices might have. So, all right. I think, Jamie, we're going back to you about the ACA case now, right?
Yes. So this term, the Affordable Care Act reached the Supreme Court for, I think, the third time. But this case was a big one because it was an effort to strike down the entire ACA as unconstitutional. And I'm guessing many of you may remember the ACA's first appearance in the court. I think it was almost a decade ago by this point. It was a challenge to the individual mandate that financially penalized people who chose not to obtain health insurance. And in that case, the court upheld the mandate as a valid exercise of Congress's power to tax. But then in 2017, Congress decided to reduce that tax penalty to zero. And after the legislation was passed, a coalition of Republican governed states, led by Texas, and some individual citizens of those states brought a new challenge to the ACA. They argued that the individual mandate couldn't be justified as constitutional under the power to tax because there was no tax anymore. And they went on to say that if the individual mandate is unconstitutional, then the entire ACA should be struck down. And I think it's worth noting that this position came under fire from lawyers and legal scholars across the political spectrum, conservative and liberal alike. And what they pointed out is that if one provision of a statute is unconstitutional, and just kind of assuming for purposes of argument that there could be a valid argument that the penaltyless mandate is unconstitutional. But if that happens, what courts do is they decide whether that provision should be severed from the rest of the statute. And they look at whether Congress would have wanted the whole statute to fall if one provision was essentially outlawed. And we know pretty much for certain that the 2017 Congress did not want the ACA to fall because the whole point of the legislation they passed was just to zero out the penalty, not to get rid of the whole thing altogether. But a district court agreed with the challengers, and the Trump administration decided not to defend the ACA at all. So the House of Representatives and a group of blue states led by California intervened to defend the statute. It ended up kind of being a little bit of a not as exciting of a case as one might imagine, because the court never reached the constitutionality issue or severability. It basically ducked those questions by holding that the challengers couldn't pursue their lawsuit at all because they couldn't establish that they were harmed in any way by a mandate that imposes no penalty for failing to comply with it. And that's a doctrine known as standing. It's a constitutional requirement that people who file lawsuits in federal court have to demonstrate that they are personally and tangibly injured by the conduct or the statute that they're challenging. And we'll see standing come back a couple times today. And a 7-justice majority that notably included Justice Barrett, Justice Kavanaugh, and Justice Thomas all held that the challengers hadn't shown any injury here. I think the bottom line of this case is that I suspect it's going to put a nail in the coffin of ACA challenges finally. I think this was really a strong sign by the court that it really, really doesn't want to hear any more ACA challenges. And I think the near consensus in rejecting the lawsuit could make it really hard for anyone to challenge the statute in the future. On the other hand, I think it's also important that the standing ruling could make it difficult for blue states to challenge legislation that's enacted by a future Republican-led Congress. And I think if you listen to the argument, you'll see that California really didn't want to be making the standing argument that it was making. It didn't like that argument. It didn't really want to be part of placing limitations on a state's ability to sue on behalf of its residents. So I think we'll just have to see how that plays out in the years to come.
Yeah, and Deepak, you're talking more about standing with the TransUnion case.
Yeah, I am. So this TransUnion case, I'm glad Jamie teed up standing for all of you, because I think this is a really a great illustration of what I was talking about earlier about this category of cases that the court decides that can have a huge impact on the day-to-day of cases that are coming through the court system, but that people are just not going to talk about. And so I'm going to do my best to try to explain this in a way that cuts through all the legal technicalities and jargon, because you know, this is something people need to understand the court is up to. And you know, I said when I was discussing the Ford case that it was surprising that the court ruled in favor of the little guy over corporations in a classic civil justice case. This is an example of the opposite. This is an example of where the corporations won very, very big. And I think the court knows that it's not going to get the public attention that it deserves. And it's also a case in which the result was 5-4. And Clarence Thomas joined with the liberals, and even that was not sufficient for the little guy to win. So it shows you the impact of having a 6-3 Supreme Court. So the facts of this case involve TransUnion is a credit reporting agency. And what they did was they had a service that attempted to report whether people were on the federal government's terrorist watch list, or actually not the terrorist watch list, another list that has to do with whether or not you're engaging in violations of federal sanctions with the Treasury Department. And so it would be a really big deal if your name showed up on one of these lists when you were going to, say, buy a car or enter into a loan transaction. That's exactly what happened to the named plaintiff in this class action case. He went to buy a car, and the car dealership wouldn't sell him the car because he turned up on this list. And it turns out this was not a very well-designed service. All they did was check to see whether your name was the same as someone else on the list. So if you have a common name and it just happens to match somebody else's name, you were on this list. So I think, you know, from one perspective, the facts of this case were compelling. But there were 6,000 people in this class action, and only some of them actually had their names reported to third parties. Other people, their names were on the list, but their names actually hadn't been reported out. And the court analogizes this to having a letter that says really bad stuff about you that's just kind of sitting in a desk drawer. So imagine that there's a letter that somebody wrote and it says, you know, you are a criminal, you are a liar, there's all sorts of bad stuff about you, but it's just sitting in a desk drawer and nobody sees it. Do you feel harmed by that? I don't know, it's almost a philosophical question. But if you knew that there was a very good chance that that letter was going to be mailed out to all sorts of people who might, you know, give you a job or give you credit, you might be worried about that. That kind of basic philosophical question is, believe it or not, at the heart of this case. And what the Supreme Court says, following up on another case that they had decided a few years ago called Spokio, what the Supreme Court says is it's for us to decide. It's not for Congress to decide ultimately whether there's an injury. So even if Congress says, you know, we're going to give people the right to sue if their privacy is invaded, or if there are other kinds of things that we regard as a harm, the court says no, it's for judges to decide whether that is, in their words, a sufficiently concrete harm. And In my view, I'll just say this is a mistake because I think it's a metaphysical or philosophical question what society regards as a harm. But the court says that this is something that judges can do, and the way judges can do this is to basically ask a historical question. At the time of the framing of the Constitution in 1789, was something close enough to this something that you could sue about? And if so, we're going to say that's a harm. Otherwise, we're going to say it's not. I suspect that this is going to result in a whole lot of litigation, and that even garden variety claims that were previously okay are going to be thrown out by judges. So it's an example of where the court is constitutionalizing an area, basically constitutionalizing tort reform and allowing judges to second guess judgments made by the political branches, all in the name of separation of powers. So a really consequential decision that I think is probably not going to get the public attention it deserves.
Yeah, I think so Dan's going to talk a little bit more about standing coming from a slightly different direction, but the standing doctrine there's a long history of the court. I think it was Chemerinsky who had written an article or something about the closing of the courtroom doors and the sort of trend with the starting under the Rehnquist court and into the Roberts court of just making it harder and harder to sue people and hold anyone, whether it's the government itself or corporations, accountable for things that they do. The standing doctrine is one of the ways that the court has made that harder, and this Deepak's case, as well as the ACA case, I think not just being sick of hearing about the ACA, but also seeing an opportunity to again further narrow standing doctrine. That's one of the reasons I think the court came out the way they did with the ACA case and with the TransUnion case. Now there are a couple areas where they're pretty happy to allow lawsuits, and Dan's going to talk about one of those areas.
Wait, actually, Jason, can I take 15 seconds just to mention one point that Justice Thomas made in his dissent in TransUnion, which is that standing is a requirement that applies only in federal courts. So state courts could end up being a forum for adjudicating these types of statutory rights where there's no concrete injury in fact. I don't know that it's entirely clear that that is correct, and many states have similar standing requirements to federal courts, but I do think it's interesting, and I kind of wonder what it means for things like the ACA case and other types of challenges. And certainly, I think there's legislation happening in Texas right now about being able to sue, related to abortion violations that would definitely not work in federal court, that might work in state court.
Right.
Yeah, I think that's a really important point. And one thing that's interesting about standing is when the court says you don't have standing to enforce it, it doesn't mean that the statute's unconstitutional. It can still be out there. And that is the one point that Justice Thomas made. The other thing I'll say about Justice Thomas's dissent before we move on to a different standing question is if you were just to read that dissent, it not only is it incredibly well crafted, but if you read it blind and you didn't know who wrote it and you said, guess who wrote that opinion? My guess is you'd say Justice Kagan. And after Justice Kagan, you're like, no, it wasn't her. You'd probably say Justice Sotomayor. And then no, how about Justice Breyer? It would take you a lot of picks before you got to Justice Thomas. So the court really is sometimes kind of caricatured about having, they're really just ruling there are 6 Republicans and there are 3 Democrats. That is totally wrong. They have their own jurisprudential philosophies. They approach issues as individuals. You don't always see sort of breakdowns, and really do have to think how they think about certain issues. So, but with that said, now let's move on to a case that is incredibly hard to pronounce. But one trick, if you want to know how to pronounce a case, is you pull up the oral argument, you see how the chief pronounced it. And he pronounced this one, Uzebionem versus Przewski. And this case is a standing case from a different perspective. These were 2 college students in Georgia who were Christian evangelicals, and they wanted to talk about their religion and hand out religious leaflets on campus. And the campus at the time had a policy that said that you couldn't do anything that, quote, disturbs the peace and or comfort of persons, which is a pretty vague policy. It's kind of hard to know if you're going to run afoul of that or not. In this case, the 2 students were accused of violating that policy. So they stopped what they were doing and they sued. Now they sued seeking injunctive relief, which is you're seeking relief for the court saying that you can do this in the future. And they also sought a relief for nominal damages. Now, nominal damages is normally about $1. It's really more of a statement about, here is an official declaration of your legal rights. They have been wronged. But in this case, the students graduated, so they didn't need injunctive relief anymore. They can't be subjected to a policy that doesn't exist. And by the way, the college withdrew the policy after being sued because I think they realized that would be pretty difficult to defend. So now the question at that point becomes, though, what about the nominal damages? If the only thing left in the case is a request for $1, do you have standing to seek it? Is that the kind of dispute that courts exist to decide? So in this case, 8 justices said, yes, in fact, you can raise those, and the court does have, you have what's called a redressable injury because you have a completed constitutional violation. The court can decide it, and at the end of the case, they can give you your $1. Now, the only dissenter here was the Chief Justice, and this was, in fact, I believe the first time since John Roberts joined the court that he issued a solo dissent. And he had some fun with it. I think he was a little more aggressive than sometimes he does, but I think the chief looked at this as basically saying anyone can now use the court system to get. He said, I think his framing was something like the least dangerous branch is now the least expensive venue for getting legal advice. Just come in, ask for $1, and now the courts have to go and decide that. But the majority saw it pretty differently, and they said that nominal damages, that they're not just purely symbolic. This is in fact legal harm, and it's up to you to decide if you can quantify, in greater terms how harmed you were. But there are lots of really important rights where it is hard to do that. I mean, think of voting rights. If you're not allowed to vote, what dollar amount do you put on that? It's kind of hard to quantify. So this is a decision that in this case, I think, opens the courthouse doors in some ways that the standing jurisprudence of the court normally sort of retracts the scope of cases that federal courts can hear. So I'll stop there.
Yeah, I think that's right. And I also think it's important to point out that the underlying issue in the case, and these were First Amendment speech, religion, evangelical Christians. And I think that at least the conservatives on the court were much more willing to expand standing in that kind of case. Had it been some other kind of right that they were trying to vindicate, maybe standing they wouldn't have been quite so willing to open up the standing door for that kind of case. So those underlying, kind of like the Cedar Point case earlier, where the underlying issue sometimes is almost as important as the primary issue that the court's dealing with. All right, so we got to speed it up a little bit because we're running out of time here. Deepak, you want to talk real quickly about Fulton, and we'll try to move fast.
Yeah, I will try to be quick. This is it was a case that people thought was going to be potentially the blockbuster case of the term, certainly a big case. And I think it's safe to say it kind of ends in a bit of a whimper. So full disclosure, I was one of the lawyers for the city of Philadelphia in this case, so I'm not totally neutral. This case involves, Philadelphia's foster care system. Philadelphia would contract out with private agencies to select children for foster care, and one of those agencies until recently was Catholic Social Services. Catholic Social Services objected to the city's non-discrimination policy, which applied across the board to all city contractors and said you can't discriminate on the basis of race or sexual orientation, among other things. And the city had decided not to renew its contract with Catholic Social Services, claiming that they violated both the city's non-discrimination ordinance and this policy, then the terms of the contract. So as this case came to the court, people thought this was going to tee up the big issue that the court had ducked in Masterpiece Cake Shop, which is, just this really thorny issue in the wake of the court's recognition of gay marriage, about how you reconcile religious objections with non-discrimination protections. And there was a widespread fear among the civil rights advocacy community and gay rights community that this was going to be the case where the court was going to not just allow religious objections to non-discrimination, but actually to overturn what has been the law on religious free exercise generally, which is this rule from a case called Employment Division versus Smith from 1990. And that case basically says, if you are a religious objector, you can't object to rules that apply to everyone neutrally in the same way. If there's a generally applicable rule and you're objecting because it violates your religious beliefs, you're still going to be bound with equal force by that rule. And folks, I think, thought that the court was going to overrule Smith. I'll be honest, I thought the court was going to go there as well. And so this is a case where the court goes up to the precipice and then doesn't go over the edge. And there will be lots of debate about whether or not the court was about to do that and then changed its mind, whether Justice Samuel Alito had originally the assignment of the opinion to do that and then lost his majority. And there's certainly evidence for that in what the court did, because Alito has a very forceful and long dissent joined only by Clarence Thomas and Justice Gorsuch to overrule Smith. And then there's a fascinating opinion by Justice Barrett, joined by Justices Breyer and Justice Kavanaugh, explaining what all of the problems that might happen, all the questions that the court would have to answer before overruling Smith, the practical difficulties in doing that. And I think that that opinion probably explains why what the court ultimately did is produce a very narrow opinion by Chief Justice Roberts that in some ways, depending on how you read it, is kind of Philadelphia specific and specific to the ordinance and the contract in this case, and doesn't really create a lot of law going forward. So it really has nothing to say about a city that simply forbids discrimination on the basis of sexual orientation without providing for exemptions, as Philadelphia's policy did. I will stop there. There's a lot to say about Fulton, but what you need to know is that the court took this huge case to try to decide these big questions and then pulled back at the precipice.
Yeah, I think that's right. All right, in the interest of time, we'll move straight to Mahoney. Dan's going to say a little bit about Mahoney.
There we go. I'm off mute. So I'll say very little about Mahoney. I think we've heard this is the big F-bomb case, and I think we've heard quite a few of those today. And since I would call on a certain participant to help out, but this was a case about a high school student who really wanted to make her varsity cheerleading squad and was stuck on junior varsity. So off campus, she was angry and did a Snapchat to about 250 of her friends that said something to the effect of F cheer, F softball, F school, F everything, and coupled it with a picture giving the big middle finger salute. So it turned out this was a violation of school policy and her cheer team's policy, and she was suspended for a year. Her parents thought that seemed a little bit excessive, and so they sued in court. The school district lost in district court, didn't take the hint, went to the Third Circuit and lost even bigger. Didn't take the hint and sought Supreme Court review, where they in fact lost again, but in a far more narrow way. And what the Supreme Court said in an opinion by Justice Breyer is that schools do have an interest in regulating off-campus speech, but that interest doesn't justify a punishment in this case for something so trifling. And as Jamie said earlier, Justice Kavanaugh really does love these school cases, and he's a basketball coach on the side, and you could see here he just was saying, like, this is just a competitive student. Good for her. She's enthusiastic. She cares, and this isn't really kind of like the most devastating form of criticism for the school. It's just someone kind of blowing off steam. And so the only thing I'll mention, it's got a lot of interesting questions on the First Amendment. And especially as it applies to schools. And normally the students lose those cases. This is the first time in a long time that a student has actually pulled out a win here. But the opinion, and I think almost by necessity, sort of leaves as many open questions as it answers. It's really line drawing problems. Think about off-campus school bullying. What do you do about that? Think of the idea that when you're posting things off campus, they can be read on campus. If you tweet something, you might be tweeting it from home, and you have no intention of showing this to someone at school. But if someone on recess or at lunch is pulling it up on their phone and it's causing a substantial disruption, what do you do about that? And so Justice Breyer tried to give some guideposts and some clues about how schools might sort of navigate, these tricky questions in the future. But I think this is going to be an area that is not really prone or susceptible to really clear and useful administrable rules, but the courts will do their best. Though I'm guessing we're not going to see another case that at least presents the Supreme Court with an opportunity to further revise the standard anytime soon.
Yeah. All right. So we had a small handful of criminal cases that we were going to talk about, but in the interest of time, we'll cut a couple of those. We'll just have Jamie talk about Jones really quickly before we get to the last case. So Jamie, tell us about Jones.
Yeah, so Jones is a case involving sentences for people who are convicted of crimes that they committed as juveniles, so juvenile defendants. And this case is important for those interested in juvenile justice, but also because it's really important to try to understand whether the court feels really bound by its prior decisions. That's a concept known as stare decisis. And it's super important for things like the viability of Roe versus Wade. So there's a little bit of historical context that you have to understand, and I'll go through it really quickly. But basically, during the last 10 to 15 years of Justice Kennedy's time on the bench, he was responsible for a series of decisions that recognized special protections under the Eighth Amendment for juvenile defendants. So first, he authored an opinion saying that juvenile defendants can't be sentenced to death. And then he authored an opinion saying that juvenile defendants can't be sentenced to life without parole for non-homicide offenses. And then in 2012, in a case called Miller versus Alabama, the court extended that line of cases and said that mandatory sentences of life without parole are unconstitutional for juvenile defendants. And then 4 years later, the court said that Miller holding was substantive, not procedural. And it took a point to say that those sentences should be really rare. They should only be for defendants who are permanently incorrigible, but it declined to create a specific set of procedures that lower courts and state courts have to use in sentencing juveniles. So that brings us to this term. In the years that followed those cases I mentioned called Miller and Montgomery, a lot of courts had continued to sentence juvenile defendants to life without parole in really huge numbers. They kind of looked at youth as just kind of a box that they had to tick off during sentencing, that they would mention it, but it didn't really have much of an impact on the sentences that they were imposing on juveniles. And so this term in Jones versus Mississippi, the court considered whether its prior cases required sentencing judges to actually find that a juvenile defendant was permanently incorrigible before sentencing them to life without parole, or if instead they just have to consider youth at some point in the sentencing process. And without getting into detail, there's really no intellectually honest way to read the prior decisions I mentioned as just requiring, consideration of youth at some point. The opinions make no sense if read that way. But in a 6-3 decision authored by Justice Kavanaugh, the court in fact read them that way. And the decision was notably joined by the Chief Justice, who had either concurred in or joined the majority opinions in the prior two juvenile sentencing cases that I mentioned. One really critical thing here is that Justice Sotomayor, Justice Breyer, and Justice Kagan dissented, and Justice Sotomayor's dissent is maybe one of her most fiery ones yet. She said, quote, "How low this court's respect for stare decisis has sunk," and she accused the majority of distorting its prior decisions, quote, "beyond recognition." And Justice Thomas actually even agreed with her, not on the ultimate merits of the case, but he agreed that the majority had basically interpreted its own prior cases to say something that they plainly did not say, and that instead, if the court's going to overrule precedent, it should just do so expressly. So every time I hear folks talk about the current Roberts Court and the Chief Justice as this, institutionalist that really cares about stare decisis, I think of cases like this, and I have real concern for many of the important precedents that I think will be on the chopping block in the coming years.
Yeah.
On that optimistic note.
Yeah. lots to be said about all of that. Fortunately, we don't have a lot more time just to say all that could be said about that. I will take a couple minutes to talk about one more case that I gave the three panelists the opportunity to choose all the cases that they wanted to talk about. And nobody wanted to talk about this case, apparently, because it's such a stinking pile of, it's such a horrible case. So I got left with the task of talking about this case. So this is the Brnovich voting rights case, which I think could be described. A lot of people in the audience might be familiar or somewhat familiar with the Shelby County case from several years ago. I think this could be described as maybe the bookend to Shelby County. Shelby County was about, so the Voting Rights Act has Section 2 and Section 5 are the main sections for enforcing voting rights. And in Shelby County several years ago, the court basically gutted Section 5 of the Voting Rights Act. And that left those who are fighting to protect voting rights with Section 2 until Congress does something, which Congress could do right now and needs to do right now, but they still haven't done. And so until they do something, Section 2 is all that's left. And those who are fighting to protect voting rights have brought litigation under Section 2. So what happened in this case is Arizona passed a couple of laws. One of them made it so that ballots that were cast in the wrong precinct would be tossed out and not counted at all. Now, of course, what that means is if you cast a ballot that's got a bunch of votes on it, including votes for statewide elections like governor or your senator or, attorney general here in Texas, we have a bunch of statewide votes that might be cast. But if you're in Arizona, the law says if you cast that ballot in the wrong precinct, then it's not just the votes that are relevant to your precinct that are tossed out. It's the entire ballot. So your vote for governor doesn't count. Now, of course, the communities that this might potentially hurt the most are lower income, lower educated communities where they didn't know which elementary school or which public library to go vote at. And so they ended up voting in the wrong precinct or something along those lines. The other law that Arizona passed was a law that banned what is sometimes called ballot harvesting, but it's essentially when you have groups that go around and collect mail-in ballots to make sure that they get mailed. And usually they're trying to serve communities where, again, lower income, maybe less access to transportation, maybe lower educated communities, maybe disabled or elderly communities. They go around and collect the mail-in ballots to make sure that their votes get counted. And Arizona passed a law to ban this and make it against the law to do that. And their argument for why they needed to do that was to protect against voter fraud. And of course, again, the communities, the ballot collection activities happen a lot in communities that, again, tend to be, might demographically tend to vote Democratic. So a lot of votes, for example, on Indian reservations get collected this way. And so the argument, the challengers challenged these two laws and said these laws have a disparate impact on minority communities. They basically infringe the voting rights of these communities and violate Section 2 of the Voting Rights Act. The court, in a 6-3 opinion, split along ideological lines. Justice Alito, the Chief Justice, when the Chief Justice is in the majority, he gets to choose who writes the opinion. I wonder if he chose Justice Alito because he didn't want to be the author of both Shelby County and Brnovich. The Roberts Court's legacy is already going to be very much we did everything we could to scale back voting rights or to open the door to allow states to restrict voting rights. But maybe he didn't want to have his name as the author on both opinions. But Justice Alito wrote the opinion, and he essentially walks through and provides 4 or 5 different ways he basically guts Section 2 of the Voting Rights Act and says, look, if this is what you're doing, you don't have a claim. If this is what you're doing, you don't have a claim. And he gives 4 or 5 different sort of standards that says, if all you're complaining about is the kind of burden that voters always have, then you don't have a claim here. The opinion makes it very substantially more difficult to use Section 2 of the Voting Rights Act to protect voting rights. It's a very consequential decision. It will make it so that one of the real ironies of Justice Alito's opinion is he says we really need to, let the states have the power to do this. Well, of course, the whole reason we passed the Voting Rights Act in the first place is because the states were using their power to control elections to discriminate. And the Voting Rights Act was necessary in the first place to take power away from the states to discriminate and to restrict voting. And he was saying that, we really need to give this power back to the states. So it's very concerning. Justice Kagan's dissent is fairly fiery. At one point, she calls Justice Alito's majority opinion a law-free zone. And a lot of that has to do with how he chooses to read Section 2, how he reads the statute. There's a lot of contortion in the ways that the statute is read in order to say that you can't protect voting rights the way that the challengers were trying to protect them. So it's a very concerning opinion. That kind of covers most of the major cases for the term. We are kind of we are really out of time. If anyone had a quick question, we could try to answer it. I don't know, do any of the panelists have anything to say? There's, besides all the cases we've discussed, there are cases coming up next term about abortion and gun rights. A lot of questions still about how the 6th justice conservative majority is gonna which direction they're going to go. There's also right now the commission talking about court reform. So I don't know if any of the panelists have anything to add in 30 seconds about any of the stuff coming up next term or the court reform proposals that are out there. Feel free to chime in.
Next term is going to be awful.
Mississippi just filed their brief, I think it was yesterday, in the abortion case, and they explicitly called for both Roe v. Wade and Planned Parenthood versus Casey to be overruled.
Yeah, that was big news. That was yesterday?
I think it was yesterday. Yeah.
Yeah. I think I was seeing most of the news this morning, but I do think it happened. The news broke yesterday, but so that's definitely big news about what's coming up next term. There is literally the opportunity presented to the court to overturn Roe next term. So
and I'm working on the gun case. They also the challengers just filed their brief. The question is whether restrictions on public carry are unconstitutional under the Second Amendment.
Yeah, and that's another big. Is this first since Heller, isn't it? That the court's taken?
Yeah, I mean, there have been a few cases, but this is the first real substantive Second Amendment case since Heller.
Right.
Yeah, it's fair to say.
Right. All right. I think I'm not seeing, well, David asked one question, but I'm not seeing any other questions. So I think that's probably it. I want to thank everybody for attending. We're honored to be able to talk about this stuff with you guys. We appreciate your attendance. Thanks again to my esteemed panel members, and that's it. Thanks.
And thank you, Jason, for putting together just a wonderful panel. You make it so clear, all of you. Thank you, Deepak and Dan and Jamie, for all your insights. And, literally anybody can understand this because of the way that you present it. You do not have to be an attorney, which is really cool. And I want to just say again to please watch your emails for our membership renewal note in August and for our kickoff in September. This is our last Zoom call. So couldn't come too soon. As I was saying in the beginning, we're not kidding. We're really, really happy to be going back to our Arts District Mansion. I have to keep saying that because it's hard to remember the new name. Our featured speaker in September will be former U.S. Attorney Paul Coggins, who's going to be speaking on voting rights and possibly some other things if certain other indictments come about by then. I'll leave you all to guess what that might be. And honestly, Jamie and Deepak, if you can possibly join us, we'd love to have you. I don't know if you'll be in Dallas, but we really hope you can join us in person someday for a luncheon. So we can't wait to see all of you again. If you'd like more information about the Dallas Democratic Forum, please visit about our recent programs and speakers. Please visit our website, www.dallasdemocraticforum.org. Wishing you all a great weekend, and we will see you in person in September. Thanks so much.